Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 69C. Section 69 talks about those additions where the assessee is not able to prove the source of the expenditure done. So for the addition under section 69C, it is the prime condition that the assessing officer has to prove that some expenditure has been incurred. Once this milestone is achieved, only after then, if the assessee gives no explanation or the explanation given by the assessee is found to be not satisfactory, only in that case the addition under section 69C is justified. In the present case, the issue before the Honorable Chandigarh ITAT-A bench was that if the assessing officer is not able to establish that whether some expenditure has been done or not, then whether in that case the addition under section 69C is justified only on the basis of some statements for which no cross-examination has been given to the assessee. This issue has been taken up by tribunal in the case of income tax officer versus Ashwani Kumar Jain, and the date of the judgment is 12th March 2025. In the present case, the assessee is an individual who have some share of profit in a firm. Some search was made on a chartered accountant A, and in that search, two persons A and M have admitted that they were into the business of converting cash into RTGS through Hawala, and on the basis of M chat, the case of the assessee was picked and additions were made under section 69C on the allegation that the assessee is not able to prove or to give the source of his expenditure. When this matter came before the tribunal said that in the present case, from the facts and circumstances of the case, it is very clear that the whole assessment has been made without due diligence and analysis. The tribunal said that in the present case, the statement given by M was retracted, and hence that statement is not worthy of credence. The tribunal said that in the present case, in the whole assessment proceedings, there were contradiction in the allegations of the assessing officer. In some part of the assessment order, it has been said that the assessee is receiving the foreign remittances, and on the other part, the assessing officer was alleging that the assessee has given the foreign remittances, and the whole assessment has been done only because of the disclosures made by the M, and even the statement of M was retracted. The tribunal said that in the present case, the assessing officer has grossly failed to prove that even some expenditure has been incurred. The assessing officer has not examined whether the mobile number relates to the assessee in the chat of M. The tribunal said that in the present case, the whole assessment has been made only on the basis of the statement for which even the opportunity of cross-examination has not been provided to the assessee. And the tribunal said that, especially in a case where the assessee has denied that the assessee has not made either any export or import, so the assessee cannot be burdened to prove a negative point. And it was the viewpoint of the tribunal that when it is alleged that the assessee has made some payments or has incurred some expenditure, then it was the duty of the assessing officer to know the recipient through the banking documents which were available on the file of the assessing officer. So in the present case, the assessing officer is not able to prove whether any expenditure has been incurred. So the application of section 69 is grossly misapplication of the provisions of section 69, and hence the tribunal deleted the addition. Friends, this case is very important because it has been seen that whenever the assessing officer do have some information from the investigation wing, then they make the addition in one section or the other, or mostly those sections are section 68 and 69 family. Those sections have their own way of making the additions, but they are very loosely used by the revenue department. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Income Tax Officer versus Ashwani, Kumar, Jain. The date of the judgment is 12th March 2025. Thank you, friends.